All right. Welcome. I'm going to call to order the Sentencing Guidelines Commission meeting. Today is Thursday, May 7th, 2026. And I will ask Director Wrights to take the roll.
Chair, please. All right. Roll call. Vice Chair Middlebrook.
Here.
Middlebrook present. Commissioner Castro. Castro absent. Commissioner Eid. Present. Commissioner Eid present. Commissioner Fraze. Present. Commissioner Fraze present. Commissioner Keefe.
Present.
Commissioner Keefe present. Commissioner Ladd.
Present.
Commissioner Ladd present. Commissioner Mazzaros.
Present.
Commissioner Mazzaros present. Commissioner Moore. Commissioner Moore absent. Commissioner Morin. Commissioner Morin absent. Commissioner Mueller. Commissioner Mueller absent. Commissioner Reeves.
Present.
Commissioner Reeves present. Commissioner Saxena. Commissioner Saxena absent. Madam Chair, and Chair Mitchell.
Present.
Chair Mitchell present. Madam Chair, there are 8 members present, 5 members absent.
All right. And so with that, we do have a quorum. Next item is adoption of the draft meeting agenda. I'd entertain a motion to approve the agenda. Commissioner Middlebrook makes the motion. Commissioner Eid seconds. Any discussion on the agenda? Hearing none, we'll go ahead and vote.
Do the Middlebrook motion to adopt the meeting agenda. Middlebrook?
Yes.
Middlebrook, yes. Castro? Castro absent. Eid?
Yes.
Eid, yes. Fraze?
Yes.
Fraze, yes. Keefe?
Yes.
Keefe, yes. Ladd?
Yes.
Ladd, yes. Mazzaros?
Yes.
Mazzaros, yes. Moore? Moore absent. Morin? Morin absent. Mueller? Mueller absent. Reeves?
Yes.
Reeves, yes. Saxena?
We can't hear
We
you.
can see you.
I apologize. I'm having some technical difficulties. Can you hear me now? Okay.
Yes,
Yes.
we can. We can hear you and see you.
Is the vote with respect to the minutes?
It's the adoption of the agenda. It's a Middlebrook motion. It's looking pretty good to pass so far.
Did you want to vote on the agenda or no?
I'm sorry. I couldn't hear you until just now. Yes, I would vote to approve the agenda.
Okay,
Thank
so
you.
Saxena, yes, and Mitchell.
Yes.
Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed, and Commissioner Saxena is not present.
Excellent. With that, the motion is approved. Next item is approval of the draft meeting minutes from April 9th, 2026. Those were sent out last week, so you all should have had a chance to review them. And I would entertain a motion to approve the minutes.
So moved.
Commissioner Eid makes that motion. Second, Commissioner Reeves seconds. Any discussion on the minutes? Hearing none, we'll go ahead and vote on that.
To the Eid motion to approve the April 9th, 2026 meeting minutes. Middlebrook?
Yes.
Middlebrook, yes. Castro? Castro absent. Eid?
Yes.
Eid, yes. Fraze?
Yes.
Fraze, yes. Keefe?
Yes.
Keefe, yes. Ladd?
Yes.
Ladd, yes. Mazzaros?
Yes.
Mazzaros, yes. Moore? Moore absent. Morin? Morin absent. Mueller? Mueller absent. Reeves?
Yes.
Reeves, yes. Saxena?
Yes. Yes.
Was that a yes?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. All right, so now we are going to move on to legislative updates, and I believe, are you taking that over, Director Wrights?
Yes, Madam Chair.
All right, so I'll turn it over to you. I have a feeling that you're talking very quietly today.
I'm talking quietly?
Yeah.
Oh, thank you. Maybe I'll just grab this.
Okay, yeah.
So you have in your packets a document that I swear was accurate when I sent it out. But it's a fast moving legislative session, so I have quite a few amendments to make to that. The document, I prepared it on April 27th. The legislative session ends on May 18th, so there's basically 10 working days left. May 18th is a little bit of a misnomer because in the even numbered years, the legislature is not allowed to actually pass any bills on the last day of session, so they have to get the work done on Sunday. So basically the first part of the paper essentially is explaining that the big deal is next month. So next month, we're going to throw a lot of information at you and ask you to make a lot of decisions. And it really is the kind of thing where you have to make decisions that week. So please read your meeting materials in advance, apprise yourself of the issues, read the bills if that would help. And kind of come prepared to discuss ranking some crimes, either new crimes or amended crimes. And it's looking like we will have some crimes to rank. So this is, despite the fact that it's a very narrowly divided legislature, they've still been able to come to some agreement on some bills. So I'm going to talk about basically the changes. If there's, and basically we'll stack at the top the bills that pass that we think, that staff thinks the commission would have an interest in making a guidelines decision about. For example, if there's a new felony, there would be a requirement to rank that, or at least there'd be a ranking decision. You wouldn't have to rank it; you could leave it unranked, but some decision would be appropriate at the June meeting. And for that reason, there is going to be a quorum required at the June meeting. So I will be asking for you to RSVP to the June meeting. So that's one of the unusual meetings. That also the July meeting, and then frequently the December or January meeting. Those are the quorum required meetings. So I'm going to pretty much focus on the changes. So the first change has to do with House File 2358. That takes the crime of coercion, which exists right now, and adds.
Are you trying to share that? Or
I'm not intending to share
Okay,
it. I
okay.
could, if you'd like me to, I'd be happy to.
I was just wondering, do people want, do you all have the materials, or, okay, then we're good.
Yeah, for the benefit of the public, I suppose it would be a good idea to share it. So let me just pull it up. I'm going to pull up the clean copy here. Okay. Good. All right. So the first bill that I'm going to start to talk about is House File 2358. So that enhances penalties for coercion. So there's an existing crime of coercion. If the coercion is by a threat to disseminate private sexual images, so there's a crime of disseminating private sexual images, colloquially known as the revenge porn statute. And if somebody commits the crime of coercion by a threat to disseminate private sexual images, and then death or great bodily harm results as a result of that threat, then there would be a felony crime under the coercion statute. So that's it seems like the instances where this comes to light have to do with suicide. So that's typically the death or great bodily harm that's resulting. And unfortunately, this is not it's happened a number of different times in at least in the United States, not necessarily in Minnesota, but it's unfortunately a common enough pattern that the legislature had to address it. So this bill has actually now passed both bodies and is on the governor's desk. So this is just a signature away from actually being on the agenda for next month. The other bill that passed is the next bill, House File 4075, which provides a uniform firearm transfer process for a person who loses firearm rights due to a conviction. So there's a number of convictions where a person could lose their firearm rights. There are some modifications to the some of the language for losing the firearm rights, but most of the language has to do with just providing a uniform transfer process and verification process, so that it's because it's not a self implementing process. When the judge orders no firearms, then what? So this is kind of the then what bill. But there aren't a lot of obvious sentencing guidelines implications to this. Moving on to the next page. I want to start starting at the section past the Senate awaiting House action. So there is a new bill that kind of sprang out of nothing last week, Senate File 4067. And it's really a compilation of some of the bills that are on the last page, or maybe it's not quite the last page of this document. No, it's farther down here where we have some of these gun bills that the Senate has they've cleared Senate committees. They're awaiting Senate action. So apparently all these gun bills essentially got consolidated into one bill last week, Senate File 4067. And then Senate File 4067 just passed the Senate on Monday. So what this bill does, I'm sharing that's interesting.
It just switched.
It just switched. I didn't intend to share my notes, but yeah, so it's 4067 is the name of this bill. And it's not on the sheet because it existed, but it wasn't doing anything that it's doing now when I wrote this memo. So it bans semi-automatic military style assault weapons. It bans high capacity magazines, which are defined as magazines with rounds of 18 rounds or more. It bans ghost guns. So those three would, if they ended up passing the House, would require ranking decisions. And then it also reenacts the binary trigger ban, which I added the footnote just because it does involve one of the commission members, and I thought it was interesting. But so those are all now advanced. They're not just cleared Senate committees awaiting Senate action, but they've passed the Senate. Whether they have a chance in the House is debatable, but at least they're moving through the process. The next bill I wanted to talk about is 4760. So this is let's see. So this bill is the omnibus bill. It basically takes House File 3990 and Senate File 4760 together, plus a third bill, which is House File 1082. So 1082 has a lot of new provisions that I didn't tell you about. So one would be it protects hospital security guards under the 4th degree assault bill. And there was an incident involving violence against a hospital security guard in the past year. It adds the crime of grooming. That made it in that bill, and that's House File 3489. The new crime of police impersonation. Well, there's an existing crime, but it basically has a penalty expansion. There's a new penalty. There's a new felony, and other crimes are enhanced to felonies. There's a provision that would increase theft penalties if the victim is a vulnerable adult. That would definitely require some ranking decisions. That'd probably be a pretty complex decision for the commission. And then it expands the crime of doxing or releasing private information about somebody's personal address or phone number, that sort of thing. Currently applies to police officers. It would expand to include correctional officers and it would expand to a new felony tier. So right now there's not a felony version of that offense. So so that's part of the House. So that's in the mix for the conference committee that's meeting this week. So there's the first meeting of the conference committee on Senate File 4760 is meeting tomorrow. That's kind of where the bill gets finalized, is in conference committee. So they're going to take all the Senate positions that are here in your materials. They're going to take, which includes, the age deception, as, whether it doesn't say it's a guidelines aggravating factor exactly, but that would be the obvious implication, is whether the commission wants to incorporate age deception as a guidelines aggravating factor, essentially impersonating a child, and where there's a child victim. Also included in the omnibus bill, besides what I just told you about House File 1080, is House File 3990. So that's the main one. And that's just below there. That includes amendments to organized retail theft, amendments to identity theft, including forged digital likeness, some victim rights actions. There was also a floor amendment. So there's one change to House File 3990 that I didn't include in here, and this is a new crime that's not otherwise on the sheet, but it would make it a felony to host or advertise prediction markets. So prediction markets are well, I guess maybe a gray area of legality right now, but it's basically where you can gamble, but it's not called gambling. Essentially, it's called a prediction market, and that would be outlawed. I think, at least from the supply side, it would be outlawed. I haven't analyzed it well enough to know whether it would also be outlawed from the customer side, but certainly it would be illegal to host or advertise a prediction market in Minnesota if that passed. So that's also part of House File 3990 that's not included in your packet. So that's those are the big changes. Otherwise, there's not a lot of change to the status on any of these. The real action, I think, this week is going to be the conference committee on Senate File 4760. That's where a lot of these issues are going to be worked out. Interestingly, the Senate File 2689 is, I thought it was going somewhere, but it seems like it's bouncing around in Senate committees, and I don't know how it's going to get out of committee and make it in time for passage in the next 10 days. And that was the bill that I talked to you about last week that would repeal medical assistance frauds offenses and replace them with a new offense. Well, a series of new offenses and a new penalty scheme. I did, after your motion or your resolution last week to recommend that there be an intermediate penalty tier between $0 and $100,000. I did speak with the Attorney General's office, and they were amenable to that. So the Senate version of this bill does have an intermediate penalty tier of $10,000 is what the AG wanted. And I told the AG, the commission doesn't have an opinion on it, but would like to see some intermediate tier there. So it could be more rationally ranked. And so they were agreeable to that. And so I didn't actually end up having to testify on the bill because the author was fine with that. The AG was fine with that. So it went through. Yeah, they still remember you, Judge Eid, over there. They said you were like the first person to do racketeering, which may come up later in today's meeting, to use the racketeering law in the context of Medicaid fraud. So that's really where we are in the legislative session. Again, I mean, if there's you know, it's not too late. I talked about use the analogy of wet cement last time. It's not too late to make changes. I would say the big spot where changes could be made would be in the conference committee. So lots of interesting things happen at conference committee, including things that weren't in either bill, sometimes just appear magically in conference committee. If, you know, one of the 7 members of the conference committee, you know, had a particular hobby horse that didn't make it very far, they can sometimes appear in conference committee. So definitely want to keep my eye on that ball and see what's going on every day during the conference committee. Any questions from the commission for me? Any questions about what, particularly for any new members, about what June is going to be looking like and what the expectations are there? All right, and it is really because of the way your charter statute is designed. It's designed in such a way that there's the primary exception for having to submit things to the legislature in advance before the guidelines change can be made is this. It's when you're immediately reacting to a new law that changed. And that's because there's an interest in having the effective date of the law, which is August 1st, coincide with the effective date of the commission, the guidelines changes.
All right, so stay tuned. More to come on that. And that, you know, dealing with any offenses that are enacted or changed will be a big part of our June meeting. So stay tuned. We'll see what they get through. Why don't we go on to 4B, which is possible sentencing guidelines, technical modifications.
Thank you, Madam Chair. So the another category of modifications that doesn't have to go before the legislature are modifications that don't like change a ranking on the grid or don't affect criminal history scores. What we'd call technical modification. And we do have some technical modifications that would be appropriate to get into the August 1st, 2026 edition of the sentencing guidelines. We're not asking for action at this time, but this is going to be a preview of what's going to be part of your June packet as well. And if I guess if there's feedback on anything, or you know, we think we should word something differently, this would be a great time for that discussion. But we're not looking at any votes today. So the first technical modification, this was an oversight in the custody status at the time of the offense. So as you recall, as part of the comprehensive review, the commission decided to take custody status at the time of the offense out of the criminal history score section, and it's where it would increase the defendant's criminal history score and move it into the duration, the offense duration section. So it's now a durational modifier. And as part of the definition of that, so basically the way it works is if you have custody status as defined, and it's a qualifying status for a qualifying offense, then you get this additional duration. But in the definition of qualifying offense, so the reason for the qualifying offense definition, instead of just saying felony, is because the commission's decision was to make it only apply to, well, to exclude low level offenses, essentially from what would trigger the custody status durational increase. So if the offense has the severity level of 2 or less, or D2 or less, then it doesn't count. So offenses of 3 or more, D3 or more, or offenses on the sex offender grid do count for qualifying offenses. What we overlooked, of course, is that some offenses aren't on the grids because they're too serious to be on the grids, but they could potentially be in somebody's criminal history. And those offenses are murder in the first degree, including murder of an unborn child. Those offenses aren't even covered by the sentencing guidelines because they carry mandatory life. Some without the possibility of release, some with the possibility of release, but they're not covered by the sentencing guidelines. And then the sort of the second category is attempted or attempted murder in the first degree or conspiracy to commit murder in the first degree. Those are covered by the sentencing guidelines, but they're not on one of the three grids that are mentioned. There's essentially a separate one-line grid that applies to attempted murder in the first degree or conspiracy to commit murder in the first degree. And because that grid isn't mentioned above there, it's just the three main grids. Essentially, we omitted murder in the first degree or attempted or conspiracy to commit murder in the first degree, which was not the intent. If somebody is on a custody status for murder in the first degree, well, they're probably in prison, but that's a qualifying custody status. They should get this durational increase, or if it's an attempt or conspiracy to commit murder in the first degree, they should also get this durational increase. So we're asking for this technical modification to comport with what was, I'm sure, the commission's intent. The second change, pretty technical, is there was a change to a statutory maximum for soliciting children for sexual conduct, which makes the example in comment 2C06 no longer correct. The example to work required that offense has a statutory maximum sentence of 3 years. It doesn't anymore. So we're asking to delete that from the comments. And I should say changes to the commentary are always going to be technical modifications because the commentary is not substantive. The third one, this is a repeal in 2025 law. I think we might have just missed this last year. A repeal of, I think it was in the tax bill. And this is where we get in trouble, is if there's a crime law that's not in a standalone bill or it's not in the public safety bill. We have in the past missed, this is not the first time this has happened, where we missed the crime. So this was, and repeals are particularly tricky because they don't show up on word searches. So, and repeals of obscure chapters are doubly tricky. So in this case, there was a repeal of essentially chapter 297D in its entirety was repealed. And that was an interesting law that required that if somebody was going to have illegal drugs, they had to buy tax stamps to put on the illegal drugs, which I don't know if anybody ever bought those tax stamps. Maybe, I mean, I'm sure there's like stamp collectors who probably bought them. I don't know, but I think I heard a story once that somebody bought them and then was surprised that police came to his door a short time later to look for the drugs. So it's pretty straightforward. We're just basically getting rid of all of these failure to affix stamp crimes. And then the fourth one has to do with, so you'll recall as part of the comprehensive review, and I should say, I've said this before, I'll let you know if anything changes, but there's no action at all in the legislature on either the commission's guidelines changes as part of its comprehensive review or on the recommendations that the commission the legislative recommendations that the commission made as part of its comprehensive review. So, you know, as I said, I've said before, that's, I guess, good news and bad news. And nothing's even been introduced that I've seen, at least last I checked, I think it was last week, I checked for any new bills that would have had any of the key words, and nothing has even been introduced yet. So, so it looks pretty good for the sentencing guidelines changes to go into effect on August 1st. And this would be consistent with those changes. The commission voted to put the ranges in the shaded cells. So right now the shaded cells do not contain ranges, but there is some language in the guidelines that says if the presumption changes from shaded, which is stayed sentence, to non-shaded, which is a presumptive commit, if it changes due to the operation of law, like mandatory minimum, then there is a range, and you've got to do the math to figure out the range. And here's the formula for you. So what the commission voted to do is just put the ranges in there so that it'll be clear. But then that made the definition of presumptive range incorrect because it limited it to it's provided for a sentence that's a presumptive commitment. That's no longer true. The presumptive range is provided for each presumptive duration. So just asking to update that definition. Part B is just for information only. There was a previous adoption of repeal of conforming guidelines changes to reflect the repeal of medical cannabis violations. But that effective date kept changing, and the last effective date was December 1st, 2025. So that has already happened and will be reflected in the August 1st, 2026 sentencing guidelines edition. So there's no commission action required for this. So that's what we're looking at for next month for as far as technical changes. So you can already see that's going to take some time. Plus we got whatever the legislature's bringing for us. So be prepared for a good productive meeting in June, I guess I could say.
All right. Any questions about any questions about that before we leave that topic? Hearing none. Now we will move on to the comprehensive review ranking project.
All right. So we have remember how I ended up with so much talking in this meeting. I think we didn't plan things through right. Okay, so here's let's see here. So this is 5A1. So these are offenses for re-ranking consideration, and this is a little bit different from the ranking packets that we've done in the past. We only have two different worksheets here, and we're asking, instead of looking at things offense by offense, to look at things a little more systemically. And some of these we talked about last month. So the two chapters that we have here, the chapter 1 are offenses that we're calling aggravated thefts. That's not a real term. I mean, we're we'll use that term for the purpose of today's discussion. But the reason we're calling them aggravated thefts is because they are ranked at at least one of the levels is ranked at a more severe severity level than we would otherwise expect given the monetary threshold that's involved. And then chapter 2 has to do with motor vehicles, theft and receiving stolen property offenses that involve a motor vehicle. So let's start looking at the aggravated theft offenses. So
Actually, can I say one thing before
Sure.
you get into the detail? You want to give me the?
Oh yeah, sure.
I'm sorry, I forgot to ground us. Last time, we have looked at a lot of the offenses on the standard grid, but the question after the set that we looked at last time was like, what else do we need to look at on the standard grid to finish our review of that grid? Because that's the grid that had the least review over time. And so the staff had brought forth some, trying to get some input on how do we look at theft? How do we look at, some of these other bigger picture things? And there wasn't a ton of interest overall in looking at the whole theft scheme. So what we talked about it a little bit more, and what we thought we would just take a look at would be the things that just on the grand scheme looked like they could be outliers that we should maybe just take another look at, to make sure that we're happy with the scheme or whether there should be any changes. So that is how we sort of narrowed in on the offenses that are in front of you. So I think that once we get through this packet, we're probably pretty done with the main grid, unless the standard grid. So I just wanted to give you that grounding that we're trying to, this is here to try to close the book on that review. And staff helped us a lot in identifying some crimes that are worth a second look. So that's what we're doing today. And now I'll give it back to you. Oh, you've got your own now. All right.
Well, the vice chair had two, so I'm not sure how that happened. Okay, so so basically what we're talking about is in terms of the 4 aggravated theft crimes. The first is identity theft, and that was I looked at the minutes for the ranking. This is a very level 8 ranking on identity theft, and the discussion was that the intangible value to the victim's credit history can exceed the actual monetary value taken. I can vouch for this from my days doing legal assistance work in the Army, that it's really hard. I had one client who had just a terrible credit score because of identity theft, and it was almost impossible to untangle that. Another client who had a terrible criminal history because of identity theft. And it was really hard to convince people that that wasn't me, kind of thing. So it's pretty tricky. So that's something that the commission has, although inconsistently, and we'll talk about that, ranked at higher levels. Then we have financial exploitation of a vulnerable adult. So there's really a couple of aspects of this, and it's interesting to me because there's, in the legislative package is a proposal to uprank or to have a higher penalty for theft involving a vulnerable adult. Financial exploitation of a vulnerable adult has that aggravating element, if you will, of the victim is a vulnerable adult. So somebody who's, it's in the term, particularly vulnerable. He's like stealing from a child. Not that every vulnerable is like a child, but I mean, in the sense that a child would also be particularly vulnerable. But the financial exploitation crime also involves a breach of fiduciary duty or the use of undue influence, harassment, or duress against a vulnerable adult. Then we have theft with foreseeable risk of bodily harm. Pretty unusual crime, but the felony statutory maximums are increased by 50% if there's a physical danger that's posed by the theft crime, regardless of whether there's actual harm that occurs. And finally, organized retail theft requires a pattern of retail theft, at least 2 separate acts in 6 months, and the intent to resell or return the items for value. And that the statutory maximums are systematically set higher than the statutory maximums for comparable theft. So the legislature is basically sending, I view the commission as being the primary audience for that message. Okay, we're setting the felony statutory maximums 2 to 5 years higher. Commission, what do you think that means? And it means the legislature thinks those are more serious. So the commission did look at these as being more serious. So identity theft is ranked at 8. Like I said last month, that's the only ranking above the dispositional line for a property offense. Then, I mean, like you have burglary here and robbery, but those are obviously what more than property offenses. You get weapons and assaults involved in those. But then it drops down to 3 and 2, which is interesting because those are kind of the rankings for regular theft offenses. They have the old $2,500 threshold, but as we discussed last month, the commission treats the $2,500 threshold the same as the $5,000 threshold. Essentially, that was a decision in 2007 to increase the threshold from 2,500 to 5,000, but it wasn't done uniformly. So the commission doesn't treat them any differently. Then you have financial exploitation of a vulnerable adult. That's a 7, so that's 1 higher than the sixes, which is kind of I'd say the normal over 35,000. And then you have 5, which is 2 higher than what you normally see a 5,000 to 35,000 be. And then you've got 4, which is also 2 higher than what you'd see an under 5,000 be. No, I'm sorry. Yeah. So I just to contrast these here, not to get too deep in the weeds, but so identity theft, you've got over 35,000 or 8 or more victims. Identity theft is a little bit different ranking there. But over 35,000 has as an 8, which is 2 higher than the normal and over the disposition line. And then it's got the other 2 at 3 and 2, where that's at normal. So it's not 2 higher. It's not 1 higher. It's at normal. Then you got financial exploitation of a vulnerable adult, which kind of goes in the other way. It only has it 1 higher, at 35,000. So it ranks that at 7. And then it's got the other 2 levels 2 higher. So it's kind of interesting how they do that. Then you have theft involving harm, which that does sort of the 1 higher. I guess one simplistic approach would just be to rank everything 1 higher if it's aggravated. That would result in an identity theft of 7, 4, and 3, and financial exploitation of vulnerable adult at 7, 4, and 3. And then theft involving harm they already have is with the 4 and 3. And then they have a special 2 here if it wasn't even a felony to begin with. So if it's under $1,000 without a prior, then it's going to be a misdemeanor or a gross misdemeanor. So that's elevated to a felony under this. It's ranked at severity level 2. Then you've got organized retail theft, which also has the 4 and 3, so the 1 higher. And then the offense that would have been a misdemeanor, gross misdemeanor, is ranked at 1. So a little inconsistency there with theft involving harm. So I guess the question is that a problem? Would it be good to have this be consistent? I mean, I guess one question I have is, what would you do if the legislature did create this new crime of another aggravated theft, which would be any theft involving a vulnerable adult? Where would that be ranked? Is this something you want to have sort of a consistent pattern so you could follow it in the future if the legislature creates additional aggravated theft situations? I mean, it wasn't too long ago it created organized retail theft, which didn't exist before. So if we look at identity theft, we do see with the has the elements. By the way, this child sexual abuse material using stolen identity. I'm not sure what the legislative intent was there. I don't understand how that crime is supposed to be committed. I don't know if the crime ever has been committed. I listened to Hennepin County Attorney Amy Klobuchar testifying before the Senate Judiciary Committee about this bill when it was being introduced, and I didn't quite understand exactly what she was getting at for, exactly what the situation here was. But I'm not really concerned about that ranking because I don't think that really happens in real life. But looking at this severity level 8 ranking, the one involving 8 or more victims or loss of over 35,000, we see that there's a really high dispositional departure rate for that. So it's over 56%. So they're all presumptive prison, 56% dispositional departure rate, 44% go to prison. The dispositional departure guidelines true zero is 84%. So really, really quite high.
Commissioner Ladd has a question.
Yes.
Thank you. Can I just ask a point of clarification? When you were giving that summary of the categories and you were talking about the severity level rankings were more than like 2 more or 3 more or 1 less? Were you talking about, excuse me, as a base ranking of the severity level, like for offense, or what? I guess I wasn't clear on what you were using as the normal ranking
So yeah,
comment.
so the normal theft ranking scheme is if it's under 5,000, it's severity level 2, which is consistent with this, which is consistent with identity theft, because they didn't adopt the 5,000 threshold in 2007. If it's over 5,000, it's severity level 3. And if the crime has a $35,000 threshold, which this one does, and it's over that, then it's typically severity level 6, although there are 2 crimes that are severity level 5. But I would say that the median, the normal ranking for over 35,000 is severity level 6. So given that the legislation, that the commission apparently thinks of this as an aggravated theft, I would expect to see this ranking here, this 2 to be, higher than that. I would expect to see the 3 be higher than that. And I would just say that the 8 is unusually high. Let's see, I think I have the minutes here, or I think I quoted from the minutes of the meeting where they ranked it at severity level 8. Let's see if I can find that. Oh yeah, so from the 2003 minutes, the commission's rationale for severity level 8 ranking appears to focus on the intangible harm to the victim's credit exceeding the dollars lost. And then the other comment that was made was that the offenses elements are very similar to the elements of a major economic offense, which is a guidelines aggravating factor. And I think the argument was basically, well, look, they've already met a lot of the elements of major economic offense. So why not rank it at severity level 8? Which I mean, fine, but then it's inconsistent with the rankings at severity level 2 and 3. Like, why doesn't that apply to those lower levels as well? And does it?
Commissioner Ladd, do you have a follow-up question or?
Well, so I just want to clarify. So what we're really talking about here in these categories, we're talking about, I know we're using the word aggravating sort of loosely, but they're thefts, but they're special circumstances regarding the kind of theft, and that's what we're looking at in, as far as a comparison. Is that is that what I'm understanding?
Right. Yeah. They
Okay.
all have these dollar value thresholds,
Okay.
which, it's pretty, it should be easy to compare dollar value thresholds. Although, their point is, well, there's this intangible loss that's not reflected in the dollar value thresholds for identity theft, which I appreciate that. And I think that's true of all of them. There's an intangible loss. I mean, there's an intangible, there's a vulnerability aspect, for example, to theft from a vulnerable adult or financial exploitation of a vulnerable adult that I think can be captured also in a higher severity level ranking. But, then the inconsistency here is, why are these ranked at severity level 2 and 3? Why aren't they ranked higher than that?
Commissioner Eid has a question as well.
I just wanted to ask, so for the figure that there were 66 dispositional departures at guidelines true 0, is that necessarily is referring to 8+ victims or loss over 35,000, right? Because those are folks that are all above the dispositional line.
Right. So if you go back to the first column there, that shows what subdivision we're talking about. So those are all under the 3(5).
Oh, I see.
And I should say that 3(6) just separated from 3(5) in 2021. And this reflects data from 2015 to 2024. So it is theoretically possible that there are some 3(6) that are caught up in the 3(5) row. I can tell you, though, that's not the case. Every time we've looked at this, we've never found a situation where there was where it involved child pornography or child sexual abuse material. That's not what this crime is about. It's about the over 35,000 or 8 victims.
Commissioner Eid.
Just wanted to ask a follow-up question. How has the commission historically balanced such high rates of dispositional departures versus you know, at severity level, I mean, at criminal history 6 for the 3(5) offense, that's less than half of the statutory maximum. Right? So I guess I'm just wondering, like, I have understood that one consideration and hitting, you know, offense levels is where you get to criminal history 6 and that approaches the statutory maximum. That can be one consideration that you have pegged it about right. Most severe criminal history is getting the most severe punishment that the legislature thought was appropriate for the offense. But then in terms of the sentencing discretion of the judges, when you have 84% of them in, you know, these cases giving people probation, it just seems like as a practical matter, it must be something about the offense conduct, right? Oh no, that's not durational. It's all the offenders' characteristics but in 84% of the cases, judges are thinking that the offenders are amenable to probation. So I'm just wondering if is there a particular view that the commission has had about balancing those two data points?
I'm gonna attempt to answer the question without answering the question. You know, the first thing to think about is one of the points you made was about the sentence actually approaching the statutory maximum. The only grid where that actually occurs on a regular basis is the sex offense grid. So the others are structured a little differently, and they're structured to there's room there for the judge to depart upward if it's appropriate in a case. But overall, we haven't necessarily put that stat max on the grid, right? So, so that's just one thing to think about that we haven't used it all the time. We've used it more as a signal of severity and in helping us determine an appropriate severity level to put it on. And then another thought I'm going to put out there is that when we see offenses with high departure rates, it's typically a signal. We've viewed that as a signal to the commission that there might be something amiss here. And but it can be a signal of many different things being amiss. Like it can be a signal that the offense itself is written very badly and we can't figure out where it should go or what the right sentence is. And so we're doing what we need to in these cases. And it could be a signal that the system disagrees with where it is and what that sentence is. So all it does is raise a red flag for us. But if there's a high departure rate, that there's something we should probably look at and look into and sort of figure it out. I don't think we have a calculus for weighing those competing factors at this stage. And I think I don't know if I have anything that would adequately answer your question on that front, but I'd invite others on the commission to provide their thoughts as to how that question should be answered.
Well, I'll just add
Commissioner
one
Heath?
thing, I mean, if the idea behind the guidelines is to create regularity in sentencing and that departures are historically have been given in a limited number of cases and we're seeing 84% of dispositional departures, I would be in favor to move this along of revisiting the ranking of this to bring it down below the dispositional line so that it matches what actual sentencing practice by district court judges is.
So what we're doing today is this is going to be your packet, or this is going to be everybody's.
Right, I'm just saying that I
Yeah,
would be
no, that's-
interested in considering it.
Yeah,
Not,
yeah.
I know we said earlier we weren't gonna look at.
These we're going to look at, like these offenses that are in front of us right now. This is the smaller list of offenses.
Oh, I thought at the outset you reminded us that we talked about theft and there wasn't much appetite to look at theft in general.
Right. there wasn't much appetite in looking at all thefts. But these were, and so the question was really like, should we just leave it and move on? Or is there anything we should look at? And so these were the ones that looked like there might be something that wasn't totally in line with the scheme. Whether that doesn't mean that we can't come back next month and say that it's exactly where it should be, right? But I thought we should actually take a look at just the smaller group of offenses because it doesn't 100% follow the scheme. It feels like there's room for discussion, so I'm glad that one of the items actually did pique your interest there. All right.
Okay, so the, yeah, and I think we'd be remiss not to look at also the durational departures as well. And if you add up the 187 folks who got a dispositional departure and the 64 folks who got a durational departure out of the 330 folks, that's basically 1 out of 4 defendants got the guidelines disposition at the guidelines time. And that's with a pretty healthy range that the legislature's put in there. So, well, and I guess 2 of those got an aggravated departure, but you know, let's keep in mind that the ranking quest is to rank the typical offense. And one wonders if I mean, I think it's a fair question to ask if this is an accurate ranking of the typical offense, given that 1 out of 4 folks gets the grid time at the grid disposition. So moving on then to financial exploitation of a vulnerable adult. And maybe this is the right answer for these, you know, it's just what I find interesting is that the commission ranked these 2 higher than you'd normally see. And, but only ranked the severity level 7-1 higher. Although I guess some of these are ranked at 5. So maybe that's 2 higher than that. So this is financial exploitation of a vulnerable adult. Just interesting tidbit from research staff that unusually high percentage of these crimes are committed by women and extremely high disposition departure rates. But again, we have some lower numbers because these are not, well, you can see it in the distribution by criminal history score. A lot of people here at guidelines true 0 and some of the lower criminal history scores, and it really starts to taper off dramatically when you get into the higher criminal history scores. And then third offense, theft with foreseeable risk of bodily harm. This is the commission handled this in an interesting way, probably in response to an interesting way that the legislature addressed this. So the legislature, instead of creating crimes with statutory maximums, they just created a multiplier, and they said, okay, whatever the statutory maximum is for the theft offense, add another 50% on top of that. So the commission, instead of ranking crimes, because the legislature didn't assign stat maxes to crimes, the commission just created a rule that said, okay, whatever the theft severity level is, add 1 to that. And that's the only rule like that in the guidelines, where you have modifiers that modify the duration and modify the disposition and that sort of thing. And they can add a number of months, or they can add a % of months, or whatever it be. But this is the only modifier of the severity level. So if the theft has a foreseeable risk of bodily harm, it's ranking +1, basically. And we have here the financial divisions, but if it were a theft of a firearm, I suppose, and that theft of a firearm or a theft of controlled substance crimes, which all have their own rankings, that don't have anything to do with the financial value, or suppose theft of a motor vehicle, right? Those would be +1 under the rule that the statutory the the ranking is enhanced by 1. So, if that were going to be the rule that was followed elsewhere, then we'd have the 3, 4, and 5. Oh, except for this offense, that they did rank this at severity level 2. So if it was a misdemeanor or gross misdemeanor before, then it's a severity level 2. Otherwise, it's +1. Very infrequent, uncommon crime, but an interesting way that the commission dealt with that. And finally, we have organized retail theft. Again, pretty new crime. Not a lot of data on it yet, but so we don't have anything for you there. But they kind of follow the 3 and 4 scheme. But here it's severity level 1 instead of severity level 2. So here's your worksheet, and the first option is.
Just a sec,
sorry.
Commissioner Saxena, did you have your hand up and I missed it? Oh, we're not hearing you. Maybe talk a little bit, because before took a bit for it to come in. Help, do you have your headphones hooked up to it by any chance? No. He's not showing up with the microphone on. I can't hear you.
Is he
All
muted?
right, well, we'll keep going, and if he has a way to maybe put it in is there a chat? No, there's no chat.
Yeah, there's no chat. Can you hear me now?
Oh, now we
Yeah.
can hear you. Yeah.
I'm so sorry. I'm having a lot of tech problems today, and I didn't mean to hold everyone up. I just had a question for you, Director Wrights, about you were just going through the offense that had the severity level enhancement.
Yeah.
And I noted you mentioned that there was very few of those offenses. Given how few there are, do you have any sense of what those crimes were and whether they ever involved the enhancement? It's hard for me to think of a situation where you wouldn't just charge robbery or something else that would garner the enhancement for causing or foreseeable bodily injury. So I was just curious if you have any fact scenarios underlying that enhancement that you could share.
I haven't looked up the few cases that there are. I guess I've kind of, in my brain, I've kind of toyed with the idea of, well, maybe if you stole the, like an insulator from a power line or something, and then it caused a short, it was a low value item, but then again, the things I think about are very low value. So I don't know that those would even, come into the, enhancing the felony.
Okay.
I suppose if you, maybe if you stole a car from somebody who was stranded in the desert, and then they suffered harm because they couldn't get to safety in time. I don't know.
Law school.
Yeah, no,
So we're talking law school exam questions.
No, yeah, I know there's not a lot of deserts in Minnesota, so that's probably absurd. But you stole somebody's paddle while they were in the boundary waters or something. Maybe something like that. But
Okay.
it's I'm not sure what the real life scenarios there are.
All right, thank you.
All right, let's see. Let's see. So the structure of the re-ranking worksheet, if you like things how they are, just check the first box. And then I've got the second option is try to make it consistent. I don't know what that first check mark is really going to do there, but and hopefully you should be able to check these. Just click on whichever one you want, or fill in the blank. Unfortunately, I don't have a blank you can electronically fill in there. That was an oversight. If you think they should be made consistent, maybe you don't.
If you're trying to share, you're not sharing it.
I'm not sharing. Shoot, I thought I was.
There you
Okay,
go.
now I'm sharing. Okay, yeah, so you can check the box on which ranking you want. By the way, I don't know how to uncheck it, so be careful if you check a box. And then just, I mean, other than getting out without saving it. And then so we got these three different thresholds, and then you have the enhanced misdemeanor, gross misdemeanor, which applies to the harm, risk, and organized retail theft. And then, of course, make a legislative recommendation or other. Choose your own adventure and put in whatever you want and any notes you want. We didn't talk about a deadline for this. I'm going to ask Leah to be thinking about a deadline while I move on to the next packet.
Commissioner Middlebrook has a question.
Yeah.
Thank you, Madam Chair. So is it only one, are we ranked what if we want to do different things for different ones? What do we do?
Yeah, so that would be or other, I guess, or it's and I suppose you could, yeah, you'd have to do a word problem there. I wasn't able to think of how to handle that many different possibilities, but that's certainly something you could type in the other blank. All right, so then we get to theft related offenses involving a motor vehicle, and we do have another attachment here that I'm not going to go through with you, but it's our fiscal note. If you've ever wondered what a fiscal note looks like, you can read our fiscal note for a bill that came up. It's not, I don't think it's going anywhere. I didn't talk about it today, but it would have increased the statutory maximum penalty for theft of a motor vehicle. We inferred from that the commission would do something that we don't know that you could do, but you could do it without the bill. We inferred that you would make uniform, we inferred that you would take the crime of receiving a stolen motor vehicle and increase the ranking on that. And that's turns out to be a pretty costly endeavor if you look at the I think I'm getting ahead of myself. Let me start off by what is the current ranking scheme. So it's a pretty unique ranking scheme. So if the property is a motor vehicle and the theft statute is 2A1, which is the basic permanent theft, taking somebody's property with intent to permanently deprive them of it, then it's ranked at severity level 4, regardless of the value of the motor vehicle. If it's motor vehicle use without consent, which doesn't require permanent intent, then it's ranked at severity level 3, regardless of value. And any other theft-related offense involving a stolen motor vehicle is ranked at severity level 3 or severity level 2, depending on the vehicle's value. So if it's above or below $5,000, which is the usual ranking scheme. So that's the scheme that applies to receiving stolen property of a motor vehicle. And what we didn't know until we did the fiscal note is that according to MOC codes, which aren't the most reliable, but it's also confirmed by NIBRS data, that most receiving stolen property cases involve a motor vehicle. So we did not know that. So if this were to be ranked, say, at severity level 4, there'd be a significant prison bed cost, is what we found out in our 41 estimated prison beds would eventually be required under a fiscal note if receiving a stolen motor vehicle were ranked at severity level 4 instead of severity level 3 or severity level 2, depending on value. But it is interesting that we have this. So receiving stolen property of a firearm is ranked at severity level 4, as is theft of a firearm. But motor vehicle theft is not ranked at severity. Motor vehicle theft is ranked at severity level 4, but receiving a stolen motor vehicle is ranked at 2 or 3, depending on value. And unlike some of the offenses we've been talking about, this is not a low frequency offense. So there's we had 578 in the 10 years, so about 58 a year. This is just looking at theft of a motor vehicle. Even let's see, motor vehicle use without consent, we have 424 cases a year, so quite a few. That's ranked as severity level 3. And then receiving stolen property. These are not limited to motor vehicle cases. There's 407 sentences a year. But we do know, we believe from our fiscal note that most of these are motor vehicles. So if, particularly the ones in severity level 2 and severity level 3, most of those are going to be motor vehicles. So if, there's a little bit of a rationality concern, like why is permanent theft of a motor vehicle more serious than receiving stolen property of a motor vehicle? Like if it's at a chop shop or something, I can tell you that person has no intent of returning that property to the owner. There's an intent to permanently deprive there, but it's not theft. I suppose you could probably charge them with theft. But if it's charged as receiving stolen property, it's, yes. Oh, sorry.
I know that Commissioner Fraze had his hand up too, so let's go Commissioner Fraze and then Commissioner Eid.
Thank you, Madam Chair. I looked at these rankings and these 3 kinds of crimes, and I thought it looks right. Use without consent is not with intent to permanently deprive, so that's less serious. And receiving means possessing or receiving, etc., knowing or having reason to know the property is stolen. So not only is there no proof of actual taking of the property in the first place, but the mens rea is as low as negligence, should have known. So I guess I didn't, and then, given the low departure rates, it seems like practitioners are okay with these rankings.
Commissioner Eid?
I was just going to say what something Commissioner Gray said. I mean, the difference is I understood was that the state doesn't need to prove for the receiving stolen property charges that actually stolen. I would imagine that the quantum of proof and the common fact patterns for the theft of motor vehicle include witness accounts of the vehicle being stolen or an admission, and that perhaps many of the theft of motor vehicle charges are sometimes pled down to a receiving stolen charge, except when maybe there's a recidivist issue. And I wasn't offering an opinion on whether we should consider for re-ranking, but just responding to Director Rice's comment.
That's helpful. Thanks.
Well, and if you look at 2A1, it is pretty broad. I mean, I wonder how many. I wonder if maybe a prosecutor has an opinion on this, but could you, charge somebody who intentionally, say somebody who runs a chop shop, and this is pretty much a business where they take stolen cars from a thief and then chop them up and sell them for parts, knowing that it's all stolen and this is a criminal business. Doesn't that person retain possession of the property? Isn't I don't know. I wonder if that couldn't be charged as receiving stolen property, or instead of receiving stolen property, and you get the severity level 4 there. So that probably is a consideration, but I don't know if anybody has a contrary legal theory on that. I'd be interested to hear that. So then we have, let's see, back to the PDF. We have, again, just one worksheet for you on that, and that would be just leave things as they are, consolidate all motor vehicle theft related offenses under severity level 4, severity level 3, or something else. Keep motor vehicle use without consent at severity level 3 and consolidate all other motor vehicle related offenses at severity level 4. Keep permanent motor vehicle theft is severity level 4, consolidate everything else at 3. And then change the ranking of stolen motor vehicle, receiving a stolen motor vehicle to severity level 3, severity level 4. So, and then consolidate ranking of permanent motor vehicle theft and motor vehicle use without consent. So, or just keep it the way it is. If you like, I mean, it sounds like there's some support for that. But, you know, then I guess the other concern that I've heard raised is the loss to the victim really is as significant regardless of the value of the vehicle, right? So, you know, one person's old junker is as important to get that person to work or pick up the kids from school or whatever else it may be as somebody else's luxury car. So does it matter whether the value is above or below 5,000? So just some things to think about as you're filling out this worksheet, or anything else you want to discuss beforehand. Before, obviously, we'll be discussing this again at a future meeting. And then that brings us to the due date. 18th, so Monday, May 18th. That's same deadline as the legislature.
There we go. We're all in it together now.
All right. Well, thank you for your assistance. And then the other thing we wanted to share and is where do we go from here? I did prepare a list of one of the things that's been talked about in the past is unranked offenses. I'm going to share now just a list of some common unranked offenses. The first page kind of gives you a summary in a nutshell of what the guidelines say about unranked offenses. Either the guidelines in the commentary, you know, why an offense is designated as unranked, how that works, how a court's supposed to sentence unranked offenses. And then the final part that's in a comment, if a significant number of future convictions are obtained under one or more of the unranked offenses, the commission will re-examine the ranking of these offenses and assign an appropriate severity level for a particular offense. So that's kind of a promise that the commission's made in the commentary. So the question is, are there a significant number of these offenses? So the first one, in terms of, so this is frequency in the last 2 years of data. The top of the list is aiding an offender accomplice after the fact. And something that we've been doing for, I think, most of the time since I've been executive director is we've been actually looking up the cases to see what was the main perpetrator doing, what was the crime, because there's a finite list of crimes that qualify for aiding an offender accomplice after the fact. It's the crimes that are listed in 60911. And you know, what crime was the offender was the main perpetrator committing that this person was assisting after the fact. And you can look at that on our website, and has you know, the main offense, and then what that offense would be ranked, and then what the judge ranked the aiding an offender accomplice after the fact. You know, I'll just tell a story because I was interested. There were 2 cases in Cook County.
We'll only have 10 minutes.
Okay. All right. I'll skip the story, but just 2 people can aid the same offense, even in dramatically different ways. Like have one can get their hands quite dirty, and one can just kind of be marginally aiding. So it is a challenging offense to rank. The next one is torture or cruelty to pet or companion animal, which is, you know, it's the second highest. It had, you know, has had 16 cases in the last year. It has a pretty low stat max. I think there's some concern about ranking it consistent with its stat max because this is a pretty high emotion offense that really some people can get extremely worked up about. Then we have racketeering, which has 10 offenses. it's kind of got some of the similarities to aiding an offender after the fact in that, it's based on another offense. And I assume that the fact patterns can be quite different, but honestly, I'm reluctant to say much about racketeering with Judge Eid in the room. So I don't know if there's anything you want to add to that. And we have counterfeiting currency. So the commission ranked counterfeiting currency. Well, it kind of took the low hanging fruit in 2020. There's two different ways of doing counterfeiting currency. One is actually passing counterfeit bills. And so it ranked that based on sort of the standard theft related ranking principles. And that's done. So the easy part's done. And then what's not ranked is the means for false production and some of those other ones that have to do with sort of actually creating the bills. And and there's still apparently not an insignificant number of those cases. Finally, we have motor vehicle excise tax with 3 cases in the last year. I omitted from this list any case that only had 1 offense per year. Lawful gambling fraud just had a really good year in 2024, but it's not normally on this list. So really, if you're looking for, an offense that maybe meets that that criteria that the commission put out for itself in the commentary, that a significant number of future convictions, I think you're probably looking at, you're going to draw the line above lawful gambling fraud, and you might draw it above that. But just something to consider about what the next steps are in ranking.
We have 2 questions. So Commissioner Mazzaros and then Commissioner Ladd.
I have a work emergency and I need to step away. That's what I wanted to let you guys know.
Okay. All right. Thanks for letting us know.
Apologize.
And hope everything goes okay.
Thank you.
Commissioner Ladd.
Is there a reason why on this particular data for the unranked offenses we used a 2-year period, and the other data we're looking back 10 years, 9 years, 8 years? Is there a reason why we only look back 2 years on the unranked offenses?
Well, I was in a hurry. It was something that was suggested to me. I think I did this the day that the materials were due to you, and I think I could only do 2 years in my head is the answer. But I also made sure that I wasn't seeing patterns that were. I don't think I missed many offenses that have, let's say more than 1 a year on average. I think any offenses that aren't on this were probably in the neighborhood of 1 a year on average, and that would include lawful gambling fraud.
Is there something that's sticking out to you, Commissioner Ladd, that you're thinking that we need to take a look at?
Well, I guess the comment about how we promise to look at something if we start seeing, I don't know what the language was again, an increase, and so I didn't know what that means definitionally about like an increase and what that number is. But if our data set is like on an average year, how many are there? And if it gets to a certain number, that's when we're going to really buckle down and look at ranking these unranked offenses. Otherwise, not. I mean, I guess I was trying to understand sort of the methodology behind tripping the wire when we would, and why, again, we're just looking at 2 years as opposed to a longer time period.
Those are all good questions. Thanks for raising it. Commissioner Eid.
I agree with Commissioner Ladd's point that it might be helpful to expand the data set to a longer period of time. And then it would be also helpful to know, I think, what the rankings that are assigned, like to have a distribution. Because it seems to me like a big factor in favor of deciding to rank would be if there's a huge disparity among, if a lot of random different rankings are being assigned these unranked offenses by the district court judges. But I also suspect some of these offenses, like you said, Director Wrights, about aiding an offender, racketeering, I think, will depend on the predicate offense.
Right.
So, some of them may not lend themselves to ranking because they can be so dependent. But I mean, others of these are very specific. But that doesn't mean I'm against looking at it. I just anticipate that might be a frustrating part of the process of trying to figure out what the right thing to do is.
Commissioner Freeze?
Thank you, Madam Chair. I guess I'm puzzled looking at these numbers of cases. Now, it is only for 2 years, but we've been considering re-ranking a lot of rare crimes, some of which were never prosecuted in 10 years. And so part of me thinks, well, maybe we ought to be expanding the list of unranked crimes. But on the other hand, and to the judge's point, even if it's difficult for us to rank an offense, you could argue that we ought to give all the judges the same starting point, even if we're not sure it's the right one.
Oh, Commissioner Middlebrook?
Oh, thanks, Madam Chair. One of the things that, I mean, I know from experience on the aiding an offender, there's so many different factual situations, but I would agree with Commissioner Freeze that maybe there is some guidance we can give, if it's not just, determining a rank, a specific rank, but maybe some guidance depending on what the underlying crime is. And same with the racketeering, because I know that we hear that, and we actually heard it from Judge Castro, that they really would like some guidance on those.
Yeah, I was thinking something similar, where for those offenses where the underlying crime is the driver, I find it difficult to set a rank, but that doesn't mean we couldn't have a guideline that helps the judge determine how that ranking should be set, right? Like there could be a rubric that we give them. And so maybe that's the approach we take with that and racketeering, is try to come up with a guideline that can help judges set the appropriate rank. And I don't know if there's any other offenses on the unranked list that are like that, where the predicate offense matters. But if there are, we probably could develop a guideline that would help address them all.
So I will say, if anybody's interested in doing some more self-research on this, we do have tables on our website that have the, I'll just share my screen. So this is a page on aiding an offender accomplice after the fact. This is 2023. And these are the two Cook County cases I was talking about. I just looked at them and thought, I wonder if that's the same case. And sure enough, it is. And one of the accomplices after the fact got a severity level 7 ranking. The other got a severity level 10 ranking, which is, maxing it out almost. So it's, then you read and of course she got to stay and he got to commit. And well, he was, to say he got his hands dirtier is an understatement. So, I mean, it's hard. I guess it's hard to look at all these and come up with a uniform rule. Here's somebody who got murder 1, you got 5 years or a severity level 5 assigned to it. How would that be consistent with any rule you'd come up with? So.
Yeah.
And maybe it's just coming up with reading through the complaints and coming up with a lot of stories and seeing if we can come up with some commonalities.
Yeah, sounds like a little project, a potential little project. Okay. So if there's I think there's a couple of things that I can think of coming out of this. One, if this offense and potentially racketeering are offenses that we want to think about doing some sort of further guidance on, I think we can consider that it might be something that we have to wait a little bit, get a little group together to work on and start moving it forward a little bit down the road after we get a couple other things done that we're working on right now. And then what was the other thing? And then I think that as a commission, we probably should maybe establish a regular procedure for checking the list and running that list to see what are the, where are we at with frequency on some of these unranked offenses. And it feels to me like the time to do that would be sometime in the spring. I know that it's like fiscal note season, but or preceding this period where we're going to be ranking things potentially. Because if we decide to roll it in with a ranking, would this be the time to do it, or would it need to go to December?
It would have to go to the legislature, yeah.
Oh, okay. Well, then we can do it any time of year. So maybe my ask would be,
Mhm.
can you think about a time when it would fit into our schedule to regularly, at least once a year, run those numbers, bring them before the commission so that we can determine if there's something that we should should take another look at.
I mean, right off the top, I'd say September would be a good time.
September.
Yeah.
Yeah, because then there'd be time to do that before.
Yeah, you just finished your
Year stuff.
guidelines amendment cycles. So.
Yep. So what are the, does that sound like something we should be doing, commission? Yeah, okay. So let's try to institute that as a regular process. All right.
If I can, there's two tasks that I see the way the guidelines are written. One is for the commission to periodically look at unranked offenses. The other is for staff to have data for practitioners, because one of the things that a judge is supposed to look at in making a ranking decision is how has this unranked offense been ranked by other judges in the past. So we have to keep up with the data, and that is on our website, but maybe there's a better way to present that information too.
Yeah, and I think what I'm saying is it should be an agenda item
Sure.
that we look at it on a regular basis. So even if it's out there, it's not coming to our attention. And so it should be a regular agenda item at least once a year. I don't think it needs to be any more than that. And we can try that for a while, and then if that drives us crazy, we can do it less often. All right. That is it for that item. Thank you very much. I have to get back to my agenda. Here we go. Okay, number 6 was committee updates. The Hernandez committee did not meet this month because the data is really difficult to get our arms around. So really, we're spend a little time trying to work with staff on nailing down the data that would be most helpful to understanding the policy issues. So that's what we're trying to get to, but we will be meeting again. I think we made some good progress on that front. And do you have anything on your end to report?
Yes, well, we finally got the first markup draft. I've only marked up the chapters 1 and 2, which are pretty much correspond to 1 and 2 in the guidelines. But I will be sending out some kind of meeting coordination requests to the members of the committee to see if there's some time online. I think would be the best way to meet, just to kind of get your initial feels of the direction I'm going and see if there's a different way we should go, or what the will of the committee is. So please be looking for that. I haven't quite figured out exactly how I'm going to do that. I know you all have pretty busy schedules, but we'll try to see if we can't find a time where we can meet virtually and make some progress.
Right. Executive director's report next. Quick one.
I think, yeah, given the time, I'll just leave it with the legislative update for this month, Madam Chair. Other than, I was going to talk about NASC and in August, there's a National Association of Sentencing Commissions, and we typically do fund some commission members to go to that. So it's in Santa Fe, New Mexico this year. So one of the perks of being a member, but we'll I tend to favor newer members in terms of how I put out my invitation for that. But more details to follow.
All right. I think that takes us to public input.
All right. Okay, I see one of the members of the public has her hand raised. Any other members of the public online that would wish to make a comment, please indicate so by raising your hand. I think you should all be able to raise your hand. So it doesn't look like there's anyone in the room. Okay, so we will unmute the person who's raised her hand. All right, Katie McCormick, you're unmuted.
Hi, so yeah, my name's Katie McCormick. I was here a month or so ago, talking about my story, and I came across the news the other night about a young girl who was murdered. Her name was Lily Lacano. I think I sent you guys those notes. Her mother's actually sitting with us today, listening and observing, but this family was really affected by the sentencing guidelines because their daughter was killed, and what it seems to look like, as me and her have done a lot of research, nights of research, is that it seems to be that Minnesota, sorry if there's background noise, it seems to be like Minnesota has property over, puts property over people. I'm going over all of these offenses. So I'm going over all these offenses that you guys are just talking about, and so we have all these theft, financial theft, vulnerable adult, the theft with that. So we have all these thefts. They're all at 7 and 8. Their sentences, though, are anywhere between 41 months to 78 months, while criminal vehicular homicide that killed Lily's at 6, and the person that killed her got 41 months. Has had traffic violations. So, I just see a lot of inconsistencies with treating the offenses that it's property. It just makes me so frustrated because we're treating theft over people getting hurt. I've sent you guys so much documentation, not just this time, but the last time as well, about predatory offenses. The research I've done of people who have had predatory offenses with children, but got stayed sentences left and repeated offended again. There's just a lot of inconsistencies with victim-related crimes, and so that's just kind of what I wanted to talk about. I'm just going to keep submitting all my documents because I have piles and piles, but it does start to seem that our guidelines have more of a higher sentencing level for property over people. So I just wanted to kind of touch base on that. And yeah, Emily Lacano, who lost her daughter, she's sitting here today. She doesn't want to speak. She'll probably be at the next one, but I just think it's really important that gets heard, and I will just keep submitting all of my documents that I find for you guys. But thank you.
Well, thank you for your comments today. One thing I do want to just let you know is that in our last amendment cycle, we did review criminal vehicular homicide and criminal vehicular operation, and we did make a few ranking changes there. We're in a phase right now, and I don't know if that would have changed anything in the case. I'll just say that just to level set there. But I want you to know that you're not the first person who has talked about that particular offense, and we did take it seriously and take a look. And the phase that we're in right now is that has been submitted to the legislature, and they have this session to review our changes. And if they do nothing, then our changes go into effect. So it's possible that some of what what you're looking for may have been addressed there, but I'm not sure.
Well, the other thing, because I talked to you guys about this before too, and so that was because I spent time in prison for burglary of a firearm, and so just to kind of give you where I say this possession over people, it's like, so after doing multiple case researches on burglary, I got a 41-month sentence on my first prison term, my only felony ever, and so that being said, if you were to walk into a abandoned garage, not abandoned, somebody's garage on a property, nobody's in, and you take a firearm, you get more time than walking into a building with a family in it and robbing them with people in it. That's the inconsistencies that I see that I think are wrong. I get like there's a firearm involved, but again, we're treating that firearm as the main thing when somebody who burglarizes and there's a family inside gets less, the mandatory minimum is less time than just an empty building. So it's just stuff like that I'm seeing. But again, I'll just keep submitting evidence just so you guys can see it. I love what you guys do. I think there's just a lot of broken parts of it.
No, I appreciate your views, and thank you for coming today and continuing to keep the conversation going. We appreciate it.
Yeah, bye.
And for everyone's information, the materials that Katie McCormick submitted are in your meeting materials. They were submitted just earlier this week. Well, I think she might have submitted it last week, but I submitted them, or we submitted them to you.
We definitely got them. We definitely got them. All right. I think that takes us to the end of our agenda. So thanks, everyone. We will see you next month. And just remember that ranking is the main event next in June. Unless there are any objections, I will adjourn the meeting. All right. Have a good afternoon, everyone.